Welcome to Secrets from the Scene, a show for local musicians who want to improve their music, grow their audience, and learn about Minnesota's music scene. If you're interested in talking about all things music related and meeting interesting people from our local community, you're in the right place. Welcome to Secrets from the Scene. My name is Stephen Helvig, and I'm your host. If this is your first time checking out the podcast, welcome. Thank you for giving me some time. I hope you enjoy it. This podcast is all for local musicians. We're based here in the Twin Cities, and so all of the guests that come on every episode are local to the Twin Cities and to Minnesota in general. But if you're listening from outside of this region, all the information is generally still entirely applicable to any local scene that's happening here. And especially this episode is going to be applicable to really any scene, well, in the United States at least. Before we get started, we should throw out a disclaimer quick. I just want to note that while our guest is an attorney, he's not your attorney. So everything we discuss today is for general information purposes only and shouldn't be taken as specific legal advice. If you have a legal issue, it's always recommended to consult with a qualified attorney who can provide guidance based on your unique situation. Today's guest is Jonathan Sime, who is an attorney at Spence Law Firm, which has a strong presence here in the Twin Cities. Mick Spence has been doing law for 30 years and has worked with notable artists such as Lizzo, Princess Estate, and Soul Asylum, among many others. Jonathan reached out and wanted to do this episode as a way to help the DIY community. I think a lot of DIY creators struggle with knowing how much legal stuff they should be doing. I think a lot of people kind of know, like, yeah, there's stuff to do, but, you know, when should I be hiring a lawyer? What's important? What do I not need to worry about until later? And rightfully so. I mean, it's a very confusing space. There's a lot of information to know. So today's episode, we're going to try to break down sort of the most common legal issues DIY creators face, what resources are available to you, what you need to be focused on, and maybe what you can look to later, and a lot more. I'm going to read a little bit of Jonathan's bio, and then we're going to dive into today's episode. Jonathan Sime is an attorney with Spence Law Firm focusing on intellectual property, business, and entertainment law. Jonathan was elevated to associate attorney after working as a law clerk at the firm, gaining hands-on experience in intellectual property and business litigation matters. He comes to the Spence Law Firm after working with 3 other Minneapolis law firms in various practice backgrounds. Jonathan has also contributed to a legal publication on combating obstructive litigation practices. His dedication to supporting others extends beyond the firm with active involvement in the University of St. Thomas School of Law's Intellectual Property and Data Privacy Association. In his free time, Jonathan enjoys creating music, playing hockey, and attending concerts. Jonathan has a passion for DIY music and aspires to help the community of creative built around it. Please welcome Jonathan Sime.
Hey, thank you, Stephen.
Well, I appreciate you reaching out because I think this is a really great, helpful episode for people. I'm excited to kind of break down some of these common issues and hear from a professional on this, because I think that there's a lot of chatter about things, but, you know, sometimes that's a problem, right? Because you don't know who to listen to and like who to take seriously with certain things. I do know that the audience is going to be really interested in some of these topics. Let's start by talking about what intellectual property is and why it's important.
Yeah, of course. Well, we're here to help, so I'm thankful for having us. And again, hope we can help the community. Intellectual property is split into 3 main categories. There's trademarks, copyrights, and patents. As a musician, you might not have to worry about patents. That's sort of the sciencey stuff of if you make an invention or whatever. Mm-hmm. I had a mentor early on who explained things in terms of Aerosmith. So I'll explain things in terms of Aerosmith here, where he said, so Aerosmith has the logo Aerosmith and the band name Aerosmith, and that's their trademark. They have copyrights in songs such as like Sweet Emotion, and they have a patent in the double neck guitar. And so if you think of things in that way, then that's sort of a way to break down your 3 main intellectual properties.
I was not aware that they had that patented.
Yeah. That's at least from my mentor. So if it's not true, comes from him. We'll figure that out after the episode.
Somebody will let us know in the comments.
I'm sure. And so the main one that bands have to worry about are trademarks and copyrights. Yeah. So trademark, your brand name is your band name. Mm-hmm. If you're a solo musician, even still, your name might be what is tied to your music and your merch and all of that, and that carries your trademark. It's important to protect it because, you want to make sure that no one else in the US is using your band name. If someone goes and looks you up on Spotify, then they're not going to be bombarded by a bunch of different artists and,
Sure.
maybe have to search to find which one you are. Maybe you get big and then suddenly you have to change your name because someone says, hey, I was using that first. That's sort of trademarks. Copyrights are your songs, your compositions, the sheet music that you write, the lyrics, all of the artistic side of things. And these things are held by the U.S. Trademark Patent Office. There's the Copyright Office and there's the Trademark Office. And you can register them with the government and basically get protections. So,
Yeah.
yeah.
All right. Well, let's kind of break a few of them down into some detail.
All right.
I think let's start with copyrights.
Okay.
Probably the most familiar
Mhm.
of all the, when people think about music law,
Yep.
probably the first thing that comes up is I got to copyright my stuff.
Oh, yeah.
All right. So there's a number of ways to do this. There are services that will help you file copyrights. You can also go do it yourself.
Mhm.
And there's multiple types of filings
Yep.
that you can do. You can do one song or you can do a group of songs.
Yeah.
Why don't you start by breaking down maybe the most common form of a copyright and what your suggestion is for filing a copyright?
Yeah. So as you mentioned, there are companies that'll help you. Those companies may or may not be legal companies. You don't necessarily have to be a lawyer to file your own copyright. The Copyright Office is actually one of the better self-help government offices that exist out there. So there's a bunch of resources that they publish called circulars that will explain things like how to publish a whole group of works, which you can do. So if you go into the studio and you record an album, you can put all of them together on an album and say, hey, me and my 3 other band members, all 4 of us contributed to the song. We wrote the lyrics, we recorded the masters, and we are applying for a copyright for all of them. That will typically cost, I believe, $45 to $85, depending on, the intricacy of it, but most of them should be around $45. And, it might be something that you may be able to do yourself. If not, then feel free to reach out to an attorney or someone who might know how to do it. Maybe a friend knows how to do it and they can kind of walk you through it. But again, the Copyright Office might be one of those better self-help resources that's out there. So copyrights, there's 2 different types of copyrights that are associated with any given song.
And I think that's the first thing people need to understand is there's 2 different copyrights.
Yeah. So there's the copyright that's in the sheet music and lyrics and all of that. That's the mechanical copyright. And then there's the copyright that's in the recorded work, which is, your masters and stuff like that. And so you will have 2 different copyrights in those 2 different works. And so as soon as you write lyrics to a song or put the pen to the paper and everything like that and put it in a tangible medium, then you have copyright. Now, registering it has its benefits because then you can protect it better. If someone steals your work, then you can say, hey, I made this first and here's the paper trail that follows you. You also get what's called statutory damages, which is really great if you are filing a lawsuit. And that's because the statutory damages allow you to recover from $750,000 to $150,000. The court has the ability to choose how much they're going to give you, but that's the minimum that's allowed is $750 per infringement, all the way up to $150 per infringement. So if someone steals your whole album, then each individual song that they steal is an infringement, and that's only if you register your copyright. Otherwise, you have to prove actual damages, which might be something like, I didn't have 1,000 people stream my song. I didn't have 1 million people stream my song because they went to your song instead. That was just a rip of my song.
Okay.
Yeah. And so that's one of the benefits of being able to register your copyright before something bad happens. And again, back to the mechanical copyright versus the master recording copyright. When you put the pen to the paper, you get your mechanical copyright. Now, when you fix your song to a recorded format, then you get the mechanical copyright. And those happen automatically.
The recording copyright.
Yeah, the recording copyright.
Yep.
And that happens automatically. You get your automatic protections as soon as you first fix it to a medium, is what the law says.
Yep.
Now, registration has those benefits that I previously said. And again, it's something that you can do yourself. You can seek help. Of course, our firm is happy to help you, but that might be something as a DIY artist that you're interested in doing.
Yeah.
My advice would be, before you put it into the world, you can seek copyright protections. You just send to the Copyright Office an MP3 file of your song and pay the fine or the fee, and then you just send off your song. Then you'll have a copyright protection. And I recommend doing this at least a month or before you put a song into the world.
Yeah. Let's recap a little bit of this.
Yeah, for sure.
So first of all, there's two different copyrights. One is for the song composition, what you were calling the mechanical copyright.
Mm-hmm.
The other side is for the masters, the sound recording.
Yeah.
And the reason these two are separate, for just an example, is that we have all heard an artist cover a song and have that be very, very famous. Those are two separate copyrights for good reason, right? Because somebody else wrote that song and then somebody made a new version, a new recording, a new styling of that song, but it wasn't their song. So the original songwriter still holds their copyrights, and that song composition is going to generate its royalties back to the songwriter, whereas the master, the new version of this, is going to have its own royalties, and it's going to go to the person who made this new master. But because of those two different copyrights, things get complex quickly. But before we get into all of those intricacies, there's two copyrights. In a lot of cases with local bands, there's a shared, hey, we all contributed to this, and we're going to just split it equally or whatever. And in that case, everybody's splitting the songwriting side and everybody's splitting the master side. And when it's simple like that, going to the Copyright Office, the U.S. Library of Congress or wherever, and filing a registration is very doable. Don't be intimidated by it. You can read a few articles about how to do it, ask some questions. You'll find plenty of resources, and we'll link to some of them too. You can look in the show notes for this episode to find direct links to that. I've also seen websites like Cosigned be recommended through some like music distributors like CD Baby as a service. Now it's going to cost a little bit more because there's a middleman now, but they can help you file these registrations and they make it just a little bit easier. So if that's more your speed, you can try that out too. But the cheapest way to do it, if you write a lot of songs, is to do a batch. Like if they're all going to come out on the same project, like an album, then putting them all into one batch is the cheapest way to do it. But it can get complicated if there's different arrangements for every song. if
there's different people working on a same song or on a different songs in an album.
That's what I mean. Yeah. Like, hey, this person wrote this song and then just this person wrote the other song. Then you really can't start batching things together. The group registrations, and correct me if I'm wrong, really need to be consistent. It's like all these songs have the same kind of registration.
Yeah. So if you and your band have the same splits going forward, which we'll talk about song splits later, I guess. If you have the same splits through the whole album and say all 4 members of our band worked on the song equally or what have you, then you can just register it all as in one album, pay the fee one time, and it's easy that way. But if you bring in a featured artist, if you bring in someone who mixes a certain song, or if you have someone who puts their own notes on a song or whatever, that might require you to split it out differently. Now, it might not be something that you have to worry about, but it is something that you should think about before going and filing for your copyright.
Yeah.
Once you file for your copyright, now everything isn't necessarily set in stone, but you should be able to track back who was, in the studio giving input on a song, or who was, playing anything on any given track. And so taking notes of those things is very important, because we've seen some instances where someone was maybe just hanging out on the couch and they say, hey, I think your drum beat would sound better if you put a hit on the 2 instead of the 4. And then they might have a say in the song unless you put that in writing before the song goes out into the world.
Yeah. Let's get to split sheets and the sort of song agreement stuff here in a little bit. I want to touch back on what you were saying with, as soon as you write down your musical composition, you technically have some protection. And when you get a recording, even if it's a voice memo, you get some protection. Now, this is sort of in this area where that's true. And so then that can circulate of like, well, you already kind of have a copyright as soon as it's written down. But it's different than actually filing the full registration. And those differences mostly come in what you're able to recoup financially, correct?
That is one of the main differences. The other difference is you have to think about it from what happens when the worst happens and someone steals your song. Then you have to be able to prove, hey, I wrote this song and I wrote it back a few years ago before they published their song. And then it kind of becomes a he said, she said situation.
Right. Where if you have a registration,
it's
we
a
know
set
the date.
Yeah. And the judge can look back at that date and know for sure that you're there. You qualify for protections. Those protections of $750,000 to $150,000. per infringement. And you can also file for attorney's fees, which, are typically granted if it's some obvious form of copying. So then you can protect your copyrights very firmly. And it's better to pay the 45 up front rather than have to worry about the headache down the line.
Yeah. Okay. So a couple things on this before we move on, because I think this is the most common conversation when it comes to, even though it's kind of the simplest in some ways, it's like copyrights, right? Just register them. But it doesn't always happen. And for a couple of reasons. One, I think some people are just intimidated of like getting the paperwork done.
Mm-hmm.
But two, if you do write a lot of songs, filing a copyright every time can be like, man, $45, especially for a local musician where it's like, nobody's stealing my songs,
Yeah.
So I do see that side of it of like, I have typically taken the stance of like, if I've got a large collection, then I'll do that,
Yeah.
But I don't get too like, hey, every single thing I need to do needs to be registered right away. Right or wrong, but I think that's a common feeling. I think obviously if you've got attraction, you've got a bigger audience, it's a no-brainer.
Yeah.
You should be on top of that stuff. For people that are just starting out, you can wait until you have a group of songs. Because here's the thing. I've had a lot of new artists come in, and it's usually brand new, that have been super worried about like even sending the demo to me. Like, I don't want anybody to steal this. And I'm like, listen.
Yeah.
I know that stuff happens, but nobody's stealing random, like, unsuccessful songs, generally speaking. I mean, maybe you can speak to some instances, but I do think that there's two sides to this where, like, yes, it's good to be safe and it's good to do these things, but also you do not need to be, like, fearful of every single possible bad thing that could happen, because a lot of these things are like, it's just, don't let that stop you from moving forward.
Yeah. So the music industry, there's a lot of collaboration that goes on, and you're only going to get so far without collaboration. So if you're sending a song to someone like Steven to kind of mix your song and produce it, and they're afraid to send you a demo, know that that copyright has attached already, and keep a paper trail. If you're worried about it, keep a paper trail that you sent it to Steven on X date. Keep a paper trail, a log that, you went and recorded this demo on this date or what have you, so that you can have a journaling of when things happen. And that's something that you can be proactive about. And then, if you email something to a producer, say you email it to Steven, and then, the worst happens and your song does get ripped off, then you at least have that trail, and the law already protects you in common law rights of copyright, because that attaches as soon as you record it and as soon as you write down the sheet music. Once it's fixed to a physical medium is what the law says.
Yeah.
Yeah.
I think that's great. If you're using email, boom, right there, you've got a paper trail in that sense. Yep. And that should be enough for most cases. The other thing, I want to speak to the majority of this audience, which is, local musicians that don't have like massive amounts of income coming in from these recorded works in the first place. Let's say the worst happens. Even then, like, hey, I wrote this great track, I shared it with somebody, and then I noticed that they kind of stole that idea or whatever. But at what point, like at what money amount is it even worth pursuing?
Again, if something was registered, then you have those statutory damages. If you have the situation where...
Sorry, let me jump in right there. Those statutory damages, those are just like you get that no matter what? Or is it up to that point if you can prove that there was that much damage to begin with?
Yeah, you get a minimum of $750 per infringement, up to $150. That's all discretionary to the judge.
Okay.
And that is just given as long as your work is registered. That's why I'm advocating for registration.
Okay.
Is because...
So if you had it registered and you can prove that somebody stole it, at a minimum, you'd be getting $750.
Per infringement. Yeah.
Yes.
So any instance, an infringement could be if they performed that song at a live venue or what have you.
Gotcha.
Then they performed it 3 times. That's $750 times 3, or whatever amount the judge gives. $750 is the minimum. And so that's why we advocate for registration. But if you haven't registered, then you can at least get what's called injunctive relief, which is when a judge will say, hey, take this off of YouTube, take this off of Spotify, basically order them to do something, or else they'll be in contempt of the court and no one wants to be there. Otherwise you'll go to jail.
Yeah.
And so you can basically get a court order saying, remove that song And if you can prove actual damages, such as people listened to this version instead of your version or what have you, then you can recover. And those are common law help that happens. But there's also the statutory damages once you register for your copyright.
Yeah.
And you also can get things like attorney's fees and stuff only if you register.
Yeah.
Yeah.
Okay. So it makes sense, right? We should register. You figure it out, then it gets easier every time you do it. Yet we know this doesn't happen all the time. Well, why is that? I think I can speak for a lot of people in that it's awkward. It can be awkward to, you're writing with your friends, you're working with peers, to be the person that's like, hey, let me get out the paper here and the contract. We need to, make this. I think that a lot of people are scared of having that conversation because it can feel a little bit like a buzzkill or just scary, in general of like, how are people going to react? Or is this going to go badly? Is there going to be a big disagreement over how this works? So let's dive into the split sheets, that idea of like these song agreements of who owns what and how, who gets to control this work in some sense. I've always been told that it can suffice just to like write anything down. If it's on a napkin or whatever, but just something quick is fine to get the ball rolling there.
Yeah.
And then after that, you can actually file a registration based off of, hey, remember that day we had agreed on this?
Yeah, and that's exactly right. And back to your point about group registrations, you can even register, say, all of your songs that you recorded and wrote in 2025. That might be harder to go back and then do it after the fact. But something like a split sheet helps because then you and your bandmates all agree to what percent everyone's getting. One thing that we've also seen is that royalties will get lost in a black hole if there's no sort of split sheet that's ironclad. There's percentages that are assigned to people. And let's say, for sake of example, there's 3 people in a band. 3 people in a band equal split is 33.3%. But that's not exactly, that's 99.9%. And so that extra 0.1% could be detrimental because then if you're getting paid out royalties and a company's in charge of, giving out everything to everyone and there's an extra dollar unaccounted for, they're not going to give that dollar to anyone. It's going to go into the black box and it's going to be unclaimed royalties and you're just going to lose out on it because they don't want to accidentally pay to the wrong person and eventually get sued down the line. So that's one reason why split sheets are so important. Another reason is that you put into effect your agreement when people are on good terms. Even if you're afraid of being a buzzkill or whatever, you want to think about these things while you guys are on good terms and while everyone's happy and, all hyped up that they just recorded their first album. They just recorded like a song. They have a great EP coming and everything like that. It's better to think about that when everyone is friends rather than down the line if things go wrong, because it just memorializes your agreement. And it's a great way to understand that everyone is on the same page because you want to continue creating great art for years to come. And you guys want to be friends for years to come. You don't want $1 or $100 or $1,000. You don't want money to get in the way. You want to be able to continue to create art as long as you can and keep the band alive.
All right, let me pull up an audience question because it's on this exact topic. Pierre Bothmer asks, lots of agreements with fellow musicians are only verbal because you don't want to be annoying. Thoughts?
Yeah, so that's a great question. And I'm going to take it back to what you said earlier about you can draft things on a bar napkin and it still works. One of the first contract cases that we read as students is about someone selling a farm on a bar napkin. In Minnesota, at least, handshake agreements, verbal agreements are binding. So you can have a verbal agreement with someone just by shaking their hand and saying, yeah, we agree to this. Now, there's problems with that because you have to prove it and you have to prove that those specific terms were said. Then, again, it goes back to you trying to convince a judge, like, this is definitely what we said 10 years ago, back when you guys were on good terms. And now you have that problem. As far as being the person to bring it up, you might not have the agreement around, but just putting the terms that you can understand into a contract, such as I'm going to get 25, they're going to get 25, 25, 25. That's the splits. It's good enough to cover that part. And you can even say, hey, the guitarist wrote this whole song, lyrics and all, so he's 100% songwriter, write that down. If you guys agree that, like, hey, yeah, we're not going to put this in political advertisements, we're not going to allow our song to be put in political advertisements, write that down. Anything that you can agree to at the moment and think of, go ahead and write it down. because so many times people will look at a contract and they'll get so afraid of all the legal jargon that's in there, when in reality you don't. That has its purpose, but if you're working off of just your own DIY ethos, then you can really, DIY yourself as long as you guys understand it. Of course, in more complicated situations, I 100% advise talking to an attorney. And, if you want, you can reach out to our firm. We do offer free consultations, but just write down what you know, because at the end of the day, that helps you be able to memorialize those terms that you are aware of at the moment.
Yeah.
Yeah.
That's great. Well, I think we've covered enough on copyrights.
Yep.
I do want to spend a little bit of time on trademark because, well, there's a lot of bands out there and there's a lot of duplicate names. Just trying to pick a name that somebody else hasn't already taken is not an easy task.
Yeah.
So, any search, especially if you have a somewhat common name, as like a soloist or something like that, you'll find there's a lot of repeat names on Spotify, right? Already.
Yeah.
So I've never done a trademark, but walk me through, does everybody need one of these? At what point do you need one? What are we doing about the amount of duplicates that are inevitable with just the amount of projects that are out there?
Yeah. So trademarks, just like copyrights, they attach as soon as you start using the trade name in commerce. So your production studio, Helvig Productions, from the date that you first used your name, you have a trademark in that name, at least in common law.
Okay.
But registering it, again, gives those beneficial protections, and it essentially stakes your claim that I am first here. Because if there's a Helvig Productions over in, I don't know, California or something, then they might say, hey, we were working since the early 2000s and you came into the picture way after us, and therefore we have a superior trademark. And to go off of that, since the trademark attaches once you first use your thing, a lot of people kind of are under the impression that they should register their trademark and then start their band. That's not the case. You should start using the name essentially as soon as possible. Now, if you know that someone else has that name, maybe hold your horses, find a different name, do something to sort of mitigate that risk. But if you're like, this is a good name, a search of the internet, search of Spotify, search of YouTube, can't find anyone who's used this name, we're going to start our band, go ahead and use that name, but then you can go and register it down the line. So trademarks are done through the trademark online system, through the USPTO. That's the United States Patent Trademark Office. And those forms, a person can fill it out themselves, but there are some situations that get more complicated. If you as an artist want to make a trademark and fill out that form, give it a shot. The trademark office might reject it on some grounds, like it's too similar to someone else's name, or you didn't fill out something correct, whatever. If they send something back called an office action, then I would probably recommend getting an attorney. It might be something as simple as like taking out the TM logo from your logo. But if it's something more complex, then that might be something where you need an attorney to navigate it with you. And again, throughout this episode, I'm going to say this: don't fill out anything that you don't understand, because that's a common pitfall for people. If you can understand it, then go for it. If not, don't be afraid to ask questions. Don't be afraid to seek help. Help is out there. There's plenty of resources. And filling out a trademark application, it is in a form and you can fill that out yourself. But if things get more complicated, don't do anything you don't understand. Go ahead and seek help.
What's a trademark cost generally?
Yeah, a trademark. Last year they cost $450, but the US government recently put an increase in that price. I believe that now it's about $600.
It's not a small chunk.
It's not a small check. Yeah. And so typically those attach to what classification of goods and services you have. As a musician, you might only have one, but then you might have more, because you might have your trademark associated with, your music, and then with the merch that you put out, or with your website. If you play at, private events or something like that, then those might be different classifications of service. And that's when, someone who knows a trademark system, such as an attorney or what have you, might help you navigate what classification of goods or services you might want to go for. Again, once you start using it in commerce, the trademark protections attach, but there are more protections if you register, and it's easier to prove to a judge, hey, I was using this since this date. I have superior rights throughout the United States.
Yeah.
So, yeah.
I think with copyrights, it's easy to say you should do them.
Yeah.
Right. Because it's accessible price wise. But I think with the trademark is a little bit, at what point should an artist really be thinking it's time to do a trademark?
Yeah. So that's very personal to each artist because it's a question that maybe they care more, maybe they're more at risk of someone sort of infringing on their trademark. But kind of as a rule of thumb, maybe it's once you're serious about your business, then you should start protecting your brand name because, again, your brand name is your band name, and protect that band name because it's what you're known as, and that's the sort of trade that you're cultivating, and that's what your audience is going to know you as. And if you're a business, you want to protect that. If you're a band, you want to protect that. So once you're serious about that, then that might be a time where you seriously look into protecting your trademark.
Sure. Okay. What other common or basic legal issues do DIY creators see or that you see on a regular basis?
What I've seen personally, just from friends and whatnot, I've seen people who sort of record things, and things can be, anything from a in-studio session or a music video or what have you, and they haven't thought about that agreement of who owns what. I'm going to use music videos as an example. In music videos, you might have a copyright in the song, but the person behind the camera or the production studio of that video might be able to attach themselves to the copyright of the video. If you're hiring someone to go be your cameraman or record the song or whatever, then you want to make sure that you have that protection. And that's as simple as just writing it out ahead of time, saying like, hey, our band or whatever person in the band or what have you should be the people who have the intellectual property rights to this. You don't want the person to then, let's say the cameraman or the production studio or what have you, to go and then start using that video in ways that you didn't intend them to use.
Sure.
Yeah. And so that's something that I have seen people not really be aware of. I've seen people not be aware of how their band is operating as a business, because as soon as you make that first dollar, you're a business. Under the law, if you don't have any business structure in place, you're a general partnership. And under the laws of general partnership, everyone has the same rights. And it basically goes by what's written in the statutes, which is not always the best for your situation. Because if you have a band of 4 people, one person wants to leave that band, they take the whole partnership with them. The partnership dissolves essentially if they cannot operate with all of the people that are part of it. And so, you might just put into writing what happens if someone leaves the band. Put into writing what happens if there's a dispute. What happens, again, splits are a good thing to put into writing. Think of that before it gets bad.
Sure.
Those are some problems that I've seen with DIY artists.
Okay, yeah. And again, just starting with writing your own agreement is fine as a starting point.
Yeah, if it's something that's not complicated, then you can write your own agreements. But if it's something that gets to be a little more complicated, or if you're presented a contract from someone else, say like a recording studio or say a venue or what have you, and there's something that maybe you're not familiar with, then go ahead and reach out to an attorney, ask them for a review of a contract, or go ahead and reach out to just try to figure out what that term means. You should never sign anything that you don't understand.
Right.
Because that's, you're giving up rights, or you're agreeing to something and you want to know what you're agreeing to ahead of time, because that eventually might lead to problems, and you'd rather know what you were exposing yourself to than being caught up in the storm.
Yeah.
Yeah.
Going back to the band agreement stuff, that's something that I've had a few conversations about, and different clients calling and just asking for like my advice if I've seen these before, like common scenarios, because people do leave bands, right? Either willfully or not otherwise. And that's one of the tough things, right? If the band's going to keep, if somebody just says, hey, I can't do this anymore, I'm moving out of state, like good luck to you, go ahead and hire your next drummer or bass player or whatever. I think a lot of times that can be great. But if it's not so amicable, then you can have some pretty hairy situations to deal with, where some people still want to be getting a cut of something that they're not contributing to help promote anymore. So I think at the very least, having a band agreement is really, really helpful, just to say like, who owns this thing, and what happens if somebody leaves? Are they forfeiting their share of everything? Because if somebody's put money into buying merch, for instance, or helped to write songs, what happens if they leave? Are they going to keep getting a cut of something, or are they going to forfeit that? I think for a lot of local bands, it would be very hard to keep paying out a cut to a member that left, regardless of what they contributed, because again, there's just not that much money going around. Obviously, if you have a fair amount of success and you've got serious royalties coming in from any one of those sources, that's a different story. So I think, again, while things are good, kind of setting up how you would want to be treated yourself if you decide to leave this band, and putting that in writing can really help out.
Yeah. So at our firm, we've drafted a fair amount of band agreements. We have them sort of canned and ready to go for whenever someone comes in and says, we need a band agreement that says blah, blah, blah. Then we can put that into an agreement and sort of get your operation going. It's important because if you have a situation where someone leaves, they still hold their copyright rights, their intellectual property rights. And so if, say, your drummer leaves and moves to a different state and they want to sell your song, I guess, again, let's go back to a political campaign that maybe the rest of you guys don't really agree with, they have that right to do so. And so that's something that you can say ahead of time and say, hey, we don't want you to be able to sell our thing to, I don't know, a political campaign or a diaper commercial or, something that even like a gambling ad or something like that, some things that might be more controversial, because that doesn't necessarily align with us. And then someone can also take their piece of the pie and kind of take it forever. And that is something that you want to think of ahead of time, because if someone worked on album 1 and 2 and then they're gone for 3, 4, 5, then, maybe they get cuts of the streams from album 1 and 2 or what have you, PRO rights and cuts from that for albums 1 and 2. But you want to make sure that they're not going to kind of dip themselves into albums 3, 4, and 5 down the line, because they are part of what is the business of the band versus the art of the band.
Mm.
And so if the business of the band is moving forward, then you guys have to put into writing and say, hey, if you are leaving, then you can still participate in albums 1 and 2, but we're going to continue on and we're going to keep playing shows and we're going to keep making merch. And you are not going to be part of that. Best of luck on your way. Try to keep things on good terms, but essentially keep the business of the band moving forward after their departure.
Yeah.
So
Absolutely.
Band agreements are important in that sense. And that's might be something where you want an attorney to step in, because then they will be able to, and an entertainment attorney, because the entertainment attorney will be able to know how the business works and who gets what, especially when it comes to intellectual property rights. It's something that you want to think about before it gets bad. And then you have to fight over negotiations rather than have peaceful negotiations.
Yeah, 100%. Let's take a minute to talk about our sponsor, Helvig Productions, which just so happens to be my studio. Are you a musician here in the Twin Cities, currently releasing music and ready to upgrade your sound? If you're tired of underwhelming recordings and want a polished, professional sound that gets people talking, we're here to help. We'll work with you to transform your next song into a production that feels impeccable, gets your friends singing along, and catches the attention of your soon-to-be new fans. And here's my guarantee. Give us 7 days to deliver a mix you love, or we'll keep working for free until you're 100% satisfied. If that sounds compelling, here's how it works. First, we'll start with a pre-production analysis where we focus on the core of everything, the songwriting and arrangement. We'll give you an honest, outside perspective to make sure your song is on track for the sound you want. And if it needs a few tweaks, we'll give you some tips and work with you to make improvements. If you want a deeper writing collaboration, we can bring in a specialized songwriter to assist. Either way, you keep full ownership of your music, no matter what. Once that's locked in, we'll jump into the professional recording and production process. This is where we capture the best performance of each part from start to finish. We'll handle everything from detailed recording to expert vocal production, editing, tuning, mixing, and mastering. Plus, all our best production assistants along the way. We've got top-notch gear, a great live room, and most importantly, over 15 years of experience helping artists get their best performances. This process has helped our clients build real fan bases and even land on Spotify playlists. We've got the results to back it up. Sharkoff built a fan base from scratch with over 99,000 YouTube subscribers and over 60 million views across platforms. Silver Warehouse got their very first single playlisted by Spotify, racking up over 3 million plays. Waltzing on Waves had a song from their debut album playlisted on Spotify, amassing 2 million plays. Ludwig landed sync deals with brands like Hyundai and shows like All American. And we've got over 80 5-star reviews on Google. So if that's all you need to hear and you're ready to chat, head to helvigproductions.com/let's connect or click the link in our show notes. We'll have you fill out a quick questionnaire, and if we're not a match, we'll let you know up front. We only work with clients who are a strong fit for our strengths because we're not satisfied until you are. If this sounds good to you, click that link and let's get started. I'm excited to see what we can create together. Let's continue to talk about actual ways of protecting yourself. There's writing down your agreements and that sort of thing. But what about something a little bit better than that? We've said you can reach out to a lawyer, but a lot of people are going to hesitate on that simply because they can't afford it. Or it's like, well, which I get. It's a fair calculation to be like, well, how much money am I actually making from this? How much money do I want to spend on this to protect from potential losses? I get it. There is a calculation there that's not always balanced. It's easy to go, do all of these things, but then you could end up spending a bunch of money. And if you're not making that back on the song, that's tough to keep repeating, right? In a perfect world, it would be free to do all these protections, but that's not the case. I know that you've looked into a couple resources for people that you could access that don't break the bank. The first one I know that you sent me was a Springboard for the Arts resource.
Yeah, Minnesota has a great local artist network, and one of those networks is the Springboard for the Arts and the Volunteer Lawyers Association. I think I'm getting that right. And the Springboard for the Arts, through their volunteer lawyers, will help people either give them a quick consultation or walk through more intricate situations. And, it might be income-based or what have you, but these resources do exist. And I know Mick works with the Volunteer Lawyers for the Arts, and I am starting to work with them. And they're a great resource. The people genuinely care. And this is not just for musicians, but this is for any artist, any person. And if you have a problem, feel free to reach out, and someone should get back to you and try to set something up so that you can get a question answered or a resource that you need. And so that is one of the things that the Twin Cities offers. The Twin Cities also offers certain subsidies for small businesses. And one of those things could be legal help. I know Hennepin County does that. I'm not sure about other counties in the Twin Cities. And that's one of the great things about the Twin Cities network is that they want to cultivate their people, their small businesses, and their artists. And so there are resources out there. It's just a quick internet search. Otherwise, I'm going to say our firm offers the free 30-minute consultations, and I know many other firms do also. So just feel free to pick up the phone and call someone. See if maybe you have a friend who knows more than you. Really take it with how much you know that they know. But there are resources out there, and there are a lot of people out here that want to lift up their fellow artists.
What do you say about, templates that exist online? People that go out and search for, I need a band agreement, and then they find some stuff on the internet.
Yeah.
Stay away from that stuff. Use it with caution. What's your viewpoint on that?
Yeah. Again, back to don't sign anything that you don't understand.
Sure.
So if you find a template and you're like, oh man, this is exactly what I need. We've had clients that use templates for things like a split sheet or whatever.
Yeah.
Those things might be more straightforward. We've had some for things like, hey, we're going to play a gig at this high school and we need just a template contract. So they pull one from online. That might be good for one gig. But again, if there's a term in it that you don't understand, either try to demystify it, reach out to a lawyer, or, do whatever you can to understand it, because there's a reason that it's in there. And, you don't want to give up anything that you don't know about just because you don't know about it. Mm-hmm. So it might take doing more homework to use a template, but they could be fine. The only other problem with templates is that they're not personalized to your situation. And no two situations are necessarily alike, but it could be good enough for a small situation. Again, make sure that you understand it completely before signing anything.
How do you feel about ChatGPT and AI, legal help?
Yeah, AI legal help is very problematic because, as we know, ChatGPT likes to sort of hallucinate things. In my mind, ChatGPT help asking it a question is about as good as Googling it. And so when you Google something, you have to really take it with a grain of salt and know where you're getting that help from. Just like with ChatGPT, the thing that ChatGPT is good at is sounding confident. And so you might take it and so, oh yeah, that sounds like the right answer. But in the legal world, we're very hesitant about it because lawyers have gotten in trouble for using it. And I'm sure that there are people who are not lawyers that have gotten in trouble for using it. So, take it with a grain of salt. It's probably about as good as Googling a question.
Yeah. Okay.
Yeah.
What about just being aware of red flags? What are the most common red flags that people could maybe keep an eye out for when it comes to a contract?
Yeah. So I actually wrote out a list here.
Sure. Yeah. Grab
but
that.
I was thinking of sending this to you so you could kind of publish it if you wanted to, or else we would publish it. But like, I'm not sure, we might publish it or something, but it's just terms that you should be aware of in a contract. So like certain things like what are the options that a recording studio is sort of taking? Like if you're signing an agreement, what are their options? Could they say, hey, we're signing you for 1 album, but we want the option for 5 albums down the line, just in case you do really well? Now, those things typically are not in favor of the artist because those things could be something that locks you in at a certain rate, and then the company that's backing you gets a better cut down the line.
Typically, this would be a record label.
Yeah,
More
yeah.
so than a recording studio.
That's what I meant to say. Yeah.
I just want to clarify that.
No, I agree. Yeah. I was thinking of the terminology and stuff, but yeah, I agree. So a record label, if they have a contract that says something like an options, and they say, hey, we want to have the option to keep you on for 5 albums when we're only signing you for 1 album originally, then that's completely at their discretion. And know that if they're doing that, your rate is probably going to go up, and you're sort of giving up the reason or the right to renegotiate that down the line.
Sure. So options. Okay.
Yeah. So options is one of them. You want to understand what you're being paid. So if it's an advance, then you want to know what the terms of that advance are. Do you have to repay it back through sales? We've seen some artists go bankrupt based on taking bad advances because they take a bad advance and then, they only get paid back 75 cents per album or what have you. And, that's sort of an impossible thing to pay back. You'd have to sell billions and billions of albums.
Yep.
So just understanding what those payback obligations are and just knowing what happens if the label doesn't recoup their money. Maybe they're going to come after you personally or what have you. Again, just be aware that if any of that happens, then what you are going to be on the line for.
Okay.
There's also things like who owns your work. So, you want to be aware of like maybe the label is hoping to take your work for the term of the contract and then they'll revert it back to you. Maybe the label is saying, we get your work forever in all exclusivity, just forever. That might be something that you might not want to do because, you want to basically have your art back, and your song might be your baby, and you want to be able to protect how it works and what you attach it to, and also how you're getting paid for it. So just be aware of what ownership means, and if you sign away your ownership, how you could reclaim control. So, even if a company has a good reputation and they've worked with some great artists and helped them blow up and be massive, there's no guarantee that they can do that for you because every situation is different.
Definitely.
So on the topic of ownership, you might also look at reversion rights. And so reversion rights could be, hey, we have this contract for 3 albums. At the end of our 3-album run, I want to be able to buy back my 3 albums. And you could buy back the rights to your albums. Or you could say something like, after 10 years, the rights revert back to you, or something like that.
Sure.
The label might have some reversion rights. They might not want to, but that's something you can negotiate.
So is there anything in terms of red flags that would, again, apply to people that aren't signing record labels, but it's maybe something super common?
So there are also some situations that might be outside of signing with a record label. And these might be something like a management contract or signing just with a certain distributor or what have you. Some distributors like to take songs in perpetuity or have exclusive contracts or what have you. And you just want to be aware of if that contract is exclusive, then you can't necessarily go to another distributor that might be helping you get your song placed in, say, commercials or TV.
Yep.
So just knowing about what terms are such as that, I think it's always a good idea to know what the term of a contract is and just how long it's going to last. If it's forever, that might be something that you might want to negotiate. If it's something that's, for a period of years, that's something you want to negotiate. And on that, you want to know how you get out of a contract. So that's another important term in just everywhere, is just how to essentially get out of it. If someone breaches the terms, there might be a notice period. There might be, you have to give them a cure, like a chance to cure that in writing by saying, hey, you didn't pay me my right royalties. And then they have 30 days to cure that. That's pretty common in contracts. But you want to be aware that that's something that you have to do in order to sort of kickstart everything. Back to management contracts, you might want to know how long you're going to be with a manager. They might want to work with you longer. because it's in their best interest as an investment to, sort of keep you on the hook longer and everything if they're working with you. But as an artist, it might be in your best interest to say, hey, let's give it a year, let's give it 2 years rather than, 5, 10 years, because that's a long time to work with someone. You don't know what could happen in that time. Yeah. And so you might get bigger than your friend or something, or what they can help you with. And so these are some things that are important to kind of retain. And again, as an artist, you're the one who's making the product. And so you have the power to negotiate. And if you have a contract, again, where you don't understand any of the terms, don't be afraid to negotiate. Don't be afraid to ask for clarity. And if it's a bigger contract, don't be afraid to seek legal help. It's better to sort it out now rather than to have a situation arise down the line that then you have to have someone help you dig you out of the hole.
Sure. All right. I want to recap a few of the things that we've talked about here in this sort of like resources and protecting yourself. First of all, about these red flags, I think it's very safe to say that if you are signing any sort of record deal, you should be talking to a lawyer. There's way too many things inside that deal that could be red flags that you just absolutely need to have help with that. You should never go into that alone, no matter how much you think you know. It's good to have a second pair of eyes on that sort of thing. So 100% consult somebody for that. When it comes to, let's say, smaller agreements or things that you feel like, I don't necessarily need a lawyer for this, I think there's certain terms that should slow you down. They're not necessarily red flags as long as you understand what you're getting into. But if you see these things like perpetuity, which means forever,
perpetuity,
you need to take pause and make sure you understand what it's referring to. And things like exclusive, because again, if you don't understand what it means exactly in the context of this agreement, that could get you into some trouble. It's not necessarily a bad term at all. That might be completely normal for whatever agreement you're getting into. Some sync things like, can often happen with exclusivity, and that's not necessarily bad.
No, it's not.
Just make sure you understand what you're signing at that point.
And don't sign anything that you don't understand. I'm also going to throw in there, don't assume that something is in the agreement just because you guys talked about it before the agreement or talk about it after, whatever. If it's something that's important, get it in writing, because if it's not in the contract, then it's, not in the deal.
Yeah.
And so that's something also to pay attention to, is what's left out. And that could be a red flag when you're dealing with someone. If they start leaving things out of a written agreement and send it back to you, it might just be that they're forgetful or whatever. Don't take it as a red flag right away, but just be aware and watch yourself. Yeah. And there's another big term that gets thrown out is something like indemnification. Indemnification is basically just one party saying, hey, if you do something wrong, then you're going to help us get out of this hole. And it might be paying their attorney's fees or whatever. It could be something like maybe you used a song with an uncleared sample, and the record label wants to say, if you create a song with an uncleared sample, then you're going to indemnify us, which is help pay for us to defend ourselves and whatnot. One of the big red flags in those situations that I have seen in contracts is you want it to be both ways. So if you're helping them out in case of a wrong act that you do, then you want them to help you out in case they do something wrong.
Sure.
Because the person who, maybe if you infringe on a copyright or the record label infringes on a copyright, they could go after the label and they could go after you. And you want to be able to say, hey, I didn't do this. I didn't place this song in the wrong area. So record label, step in and help me out. So that's a word that might be scary. It's pretty standard, but you just want to make sure that it goes both ways.
Yeah.
Yeah.
Okay. A couple other recap things here before we move on to our last section. There are free resources here in the state of Minnesota. There's a lot of great free resources. You can look at city government pages. You can, like you said, a quick Google search will pull up a lot, but one for certain is Springboard for the Arts. Does have volunteer lawyers that are available to help creatives and DIY artists through some of the basic agreements at the very least, and can maybe help you through some more complex things as well. So look them up. I'll link that resource specifically in the show notes. When it comes to using your own templates and things like that, as long as they all make sense to you, it can be a great starting place. But if there's something in there you don't understand, seek help.
Also, in specific situations, it might be best to seek help because every situation is different.
I would say it's probably better than nothing.
Yeah.
But if you understand,
Of course.
the terms, if everything is plain English enough that it's accomplishing, especially things like split sheets. But yeah, it's okay to seek help if you need it. And help can be, yes, going to a firm, but it could also just maybe be reaching out to a colleague or somebody else that you know has already had experience with this, just to at least as a first stepping stone of like, hey, does this look right? Is there a problem here? Is there something I should be worried about? You know, that still might mean that you ultimately do need to talk to a lawyer, but maybe that'll be enough to clarify some things for you if you're not ready to take it that far.
Yeah. And you could take it as far as you feel comfortable and just do things on your own. Again, DIY, we carry that ethos with us and everything. You can take it as far as you want and just sort of have that extra protection at the end of the journey. That's also totally acceptable. Is just, kind of a backup plan and stuff like that. So again, as much as you feel comfortable about, but don't take anything further than you feel comfortable with, because there is help in the Twin Cities and there's help in this community.
Yeah. Okay. Let's move on to a few real world lessons. I'm curious if there's anything I looked up a few like sort of famous cases and things like that, but if there's anything that comes to mind, maybe some stuff that you've worked on or the firm's worked on of just some sort of legal lessons that that you've seen people learn the hard way.
Yeah. So we've had artists, again, who they have their band and they don't set up the organization of who does what, who's the business guy, who's the, maybe there's, it's easy to put roles to you're a singer, you're a guitarist, you're a drummer, you're the bass player, but then it's a little harder to say, hey, you're the guy who's really good with keeping finances in order. You're the guy who's really good with reaching out to venues and booking us for shows and stuff like that. But having those conversations is very important. And one of the situations that we've seen is, someone who sort of takes the reins and everything, but they haven't necessarily put it in writing. Then once someone leaves, then they start asking for their cuts and they keep asking for cuts and everything. And as you said, DIY artists might not have all the money to keep paying them forever. Most don't, and most don't want to, but it's something that happens. And it's something that's very important to just be aware of so that you're not stuck in a situation where you have to keep paying this person. We've seen that with clients who say someone just moves out of town and they can't be gigging with them in the Twin Cities and they're across the country. Then the band essentially, falls apart on the business side and they have to sort of break down and then restructure under a new entity. And, maybe they'll get it right the second time, but who knows?
Sure.
And so that's one pitfall that we've seen. We've seen people get into sort of physical fights and stuff like that. And then that leads to situations where people then have their copyrights kind of going all over the place because of, say, criminal charges or what have you. Yeah, we've had people who start their business and everything's going fine, but then someone starts jumping in and selling songs to people that the company, that the band as a whole doesn't agree with. And so the other people kind of seek out legal help and say, hey, how can we stop this guy from sort of selling our song or using it without our permission? And if that wasn't...
So one member is giving permission for the song to be used in a way that the other members don't want it to be used.
Yeah. So if they say, hey, I'm going to sell it to, again, like a gambling ad or a political advertisement, or put it in a movie that maybe the rest of the band doesn't like because there's certain scenes or what have you, and they don't want their work to be associated with that type of stuff. If that's not something that's pre-arranged, then that band member has a copy or has intellectual property rights to be able to do that.
Mm-hmm.
And those are some pitfalls that we've seen.
Okay.
And those are some pitfalls that happen.
All right, let's go over some sort of rapid fire, frequently asked questions.
Yeah.
I think we've covered a lot of stuff already that it's like the most common, but maybe just a few more here to see what comes of it. What happens if you did sign a bad contract?
Yeah, if you did sign a bad contract and sort of stuff has happened already, then maybe you want to talk to a lawyer and see how to dig yourself out of that situation. That's kind of when you come to the crossroads of, do I live with it or do I fight back? And to fight back alone could be a big headache. That's when hopefully you've built up a good team of people around, and a lawyer should be part of that team. But it comes down to, are you willing to live with that bad contract?
Sure.
Yeah.
Is it worth registering a copyright right when you're starting out?
Right when you're starting out, the $45 to $60 filing fee could be costly. Maybe you're messing around just putting music online. you don't know whose ears that's going to hit. And so that might hit someone's ears who say they want to use that song, and they might argue that no, they didn't use your song, they created it themselves. It's worth creating a paper trail at the very least. And again, copyright protections attach as soon as you add it to a physical medium. So definitely keep a paper trail of things. It could be as simple as a journal, but it's worth considering once you start getting serious about your business, for sure.
I think if you can afford it, yes.
Yeah.
If it's a struggle, then maybe you'll be okay for a little while.
Yeah, if it's a struggle, definitely keep a paper trail.
Yeah. Can I sample music without getting sued?
No. Long story short,
Yeah.
no. That's so a lot of artists have something notion that there's the 10-second rule where if you sample less than 10 seconds of a song or whatever, then you can do that for free. There's something sort of in the law called de minimis exception, but that hardly applies. You should always clear your samples because you don't know who's going to hear your song. You don't know if it's going to blow up, and maybe they come after you, and they can come after you hard, especially if it's, as I said, those statutory damages from earlier. They work both ways. So you might be on the hook for $750,000 to $150,000 per infringement just from having an uncleared sample. If that song ends up being, say, your moneymaker or your hit song, then you might just lose it.
Yeah. Okay.
And,
so I want to, when I was looking up cases, one came up that was shocking to me. So it's the Verve versus the Rolling Stones, which happened in 1997. The Verve used a sample from an orchestral version of the Rolling Stones' The Last Time and their song Bittersweet Symphony. Although they had initially obtained permission, the Stones' management claimed the usage exceeded the agreement. The Verve ended up having to relinquish all the royalties, and the songwriting credits were given back to Mick Jagger and Keith Richards. And it wasn't until 2019 that the rights and royalties were returned to the Verve's Richard Ashcroft, resolving the dispute after 2 decades. That song's huge, and they lost all the royalties on that for that long.
And if you think about the Verve, they sort of are a one-hit wonder to where that's their one hit.
And it's a big hit.
It's a big hit, yeah. And so they lost all of those royalties to the Rolling Stones.
And not just because they stole it. They used more than what was agreed to, which is crazy to me, to lose everything over that.
Yeah. And so that's sort of one extreme cautionary tale of why you don't want to use an uncleared sample, is because as soon as you have someone else's work in your work, then they are a holder of the intellectual property rights as well. And they can sort of say how you use or don't use your work. And especially if a judge wants to kind of slap you on the wrist and say, don't do that, then they can take even more. And this is a situation where that happened, and they were fighting about it for years. I think you said 2019 was when it was finally resolved. And I know that the Verve had sort of a banger tweet at Mick Jagger saying like, I won or something like that. Because I remember when that was settled. And yeah, they lost everything for that long because the sample exceeded that scope. That's why it's very important that if you don't understand what something is saying, like how long you can use the sample or what you can use it for, say they thought, oh yeah, they'll put it in the background. If it's the violin part of Bittersweet Symphony, they'll put it in the background. It won't be a main component of the song. But then maybe the Stones were under a different impression. That's something that you want to clear up ahead of time and just sort of know what everyone agrees to. And it sucks because sometimes people might not respond to your inquiry for a sample. Sometimes people might say no. In those situations, maybe just don't use it. Yeah. Maybe you can go into the studio and recreate that sound. Obviously, it won't have the same sort of quality as the original recording because it's impossible to get that same quality as an original recording. But it's a lot better than losing all your rights to a song, and especially a major hit.
Well, and this kind of reminds me of a also recent, very popular legal battle, which was the Taylor versions, right?
Oh, yeah.
Where Taylor Swift re-recorded her previous albums to regain control of her masters.
Yeah.
You want to talk a little bit about the why behind that?
Yeah. So Taylor Swift, this goes back to what we were saying earlier with there being 2 different copyrights. Mm-hmm. There's the copyright in the master recording, and there's the copyright in the mechanical, the lyrics and sheet music and stuff. And so when you're recording music, then the master recording copyright attaches, and usually the studio or the record label will want all of your masters or want to be able to exploit your masters or what have you.
Which was the case with Taylor Swift and Big Machine Records, who owned the masters.
Yeah, so Taylor Swift signed her masters over to Big Machine. But Taylor Swift had the rights to the sheet music and the lyrics, so she essentially made a bunch of cover songs.
Of herself.
Yeah. And so she re-recorded all of these Taylor's versions, and now she's able to use these new masters that are separate than the other master.
Right. And I think she did that partially because, or maybe entirely because Big Machine got sold.
Yes, Big Machine got sold to Scooter Braun, who didn't want to give her the rights to her songs in, say, her Netflix show, or to be able to use it at performances or what have you. And that's, I guess, a cautionary tale of why you don't want to sign the wrong contract, is because you don't know who's going to flip and who's going to, have a vendetta against you for whatever reason.
Well, and Prince famously, right, changed his name to a symbol.
Yeah.
And so made that such a huge publicity thing for himself and, to be an icon, essentially, of the music industry by fighting back against, I think it was Warner Brothers, right?
I believe so. And he sort of advocated against slavery in the music industry, as he called it. And he was a huge advocate of that in his time. And he signed a contract that gave the trade name Prince, his trademark, to the label. And then the label didn't want to let him use it. And so he said, I'm not owned by anyone, and changed it, which literally Prince was his first name. And he changed it to a symbol and sort of kept working. And these are situations that happen. That now labels are sort of tightening their contracts in the wake of these situations to not have this history repeat itself. But, you also have the power to negotiate as an artist. And it's very important that you take the time to sit down and negotiate and think about, are you really comfortable with giving up what you're giving up or doing what you're doing? Again, not every situation is doom and gloom. As attorneys, we get paid to think about the doom and gloom. But it's very important to be aware of what you're giving up so that you don't end up in these situations and have to work in a way of a Taylor's version or changing your name to a symbol.
Yeah. And, I think a lot of people are just so concerned with trying to make it in the first place. And so these deals can be really, really appealing because you want help, you want a team, you want to take this to the next level, but it's exactly when you need to really fully understand what you're getting yourself into and take a second to educate yourself a bit if you're at that stage. Now, again, a lot of people here that are listening to this they're not doing record deals. It's all DIY. So they're just trying to navigate the band contracts, the copyrights, getting things registered properly. And so one of my last year questions, rapid fire legal questions here, is what's a fair percentage for a collaborator? Maybe particularly one that's not in your band. So let's say you're working with a producer that you met or just another co-writer of some sort. How do you navigate that? What's fair? What should you be offering?
Yeah. Well, so fair is very subjective to who you are. It depends on what you're willing to give up and what you're willing to do in each situation. But typical standard that we've seen is you might pay a collaborator a flat fee. So if someone hops on, sings a verse or plays a riff or what have you, you might pay them a flat fee of, $100,000, whatever amount of dollars that they ask for.
Yep.
Depending on their status and how much you want them
and the service.
What they're doing. Yeah, the service. So you can offer a flat fee. They might take it. If you're giving a percentage of your royalties, just think that they'll have a percentage of those royalties as long as the contract exists. So you can assign it to a certain amount of years. You can say you get 5% royalties for the first 10 years. You can say 5% royalties forever. We've seen anything from, say, like 3% to 10%, but be aware that that is also going to cut from the pie that the rest of the band is sort of getting.
Mm-hmm.
So you really want to think about what's fair in proportion to what they're actually doing for you.
Yeah.
And again, if you have any problems with anything, feel free to negotiate, feel free to ask for help, feel free to reach out for help because there is help available. But ultimately, don't be afraid to stand up for yourself because you're the one who's creating the work, you're the one who's creating the product. And collaborators, yeah, they're very fun, they're very important to work with, but just be willing to give up what you're willing to give up and know that what else goes into it. So you might have other things that go into what's fair, such as, are they giving up their rights to the intellectual property? Do they also have a stake in the song's intellectual property? Maybe they're tied to something with the performance, the PROs. And so anytime that royalty is paid, then they only get that, but like you guys get everything from like live performances of it. Just really think about what the deal encapsulates.
Yeah.
And sort of navigate fair that way.
I'm a big proponent of just doing work for hires as much as you possibly can, especially in the earlier stages, because it can get so complicated so quickly. Like just what you were saying right there. It's like a lot of people are going to like, I'm not following, how am I ever going to manage all that accounting? And that's fair. I think that if you can afford to just pay somebody and it's a work for hire agreement and you retain your ownership, that's really clean and good for most situations. Now, if somebody doesn't want to do that or is contributing to the point where it feels more fair to give them a writing credit of some sort, then so be it. There's nothing wrong with doing that, but then you got to do it. It's going to take more work to get that set up. So especially in the earlier stages, I think a work for hire can be really advantageous.
Yeah. With work for hires, I would say also be aware of what you're giving up, because a lot of work for hires, you were giving up the intellectual property rights to the work that you're creating to, say, the company that you're making it for, or the band that you're working with, or the band leader maybe. And so just as a work for hire, have all of that stuff sorted out beforehand of what you're essentially buying and what you're doing if you are the work for hire, and then have that rate. You can even make the rate as a work for hire a percentage of certain royalties and stuff. You could say that that's the work for hire percent. If you can dream it then and put it to writing in a way that's clear, then it can be done as long as the parties agree.
All right. I think we've covered most of what I was hoping to get through. Is there anything that you think we missed that we would be doing a disservice to leave out? Is there anything we need to circle back to?
One thing that I wanted to bring up on this episode is that right now with PROs, if you are an independent artist that has not signed up with a PRO,
Performing Rights Organization.
Performance Rights Organization. So that's your ASCAP, your BMI, those performance rights.
It's basically one of those two at this point. Yeah.
Yeah. There's a third one that's out there, but
I think it's invite only.
Okay. Yeah. So if you are not signed up with PRO, that's your homework for this episode. Go sign up for a PRO. It's simple. You can do it yourself. It's important.
ASCAP is free. BMI no longer is.
Yes, BMI is no longer free.
They just got bought, and so they're private again. And I think it's $75 to sign up with BMI.
Yeah,
ASCAP is free.
For-profit company.
Yeah,
which there might be advantages or disadvantages. That's something that I invite you to navigate.
That's another episode.
Yeah. But anyway, if you are not signed up with one as a DIY artist, sign up for one. And off of that, I am also going to say that right now Congress is doing an investigation into how PROs work. So, as a long story short, whenever your song is played publicly, then you get a royalty. So if businesses are doing the right thing, say like a restaurant or your gym or a bar or whatever is playing a song through their speakers, then they should be keeping track of that. Also, the radio stations should be keeping track of that, and concert venues should be keeping track of that. And so they report to the Performance Rights Organization, and they buy licenses to use the songs that are in their catalog. Those performance rights organizations are supposed to pay you out a percentage of how often your song was played. And so let's say your song gets picked up by a local radio station out here, then that's typically how you will get paid your royalties. If your song gets put on rotation at a mall or at a gym or local restaurant or something, you'll get paid royalties that way if they're doing the right thing. But Congress is launching an investigation into this. And I want this to be an opportunity for smaller artists to be able to have their voice heard. They're taking written submissions up until April 11th. So if you have a problem with how PROs are working, as an independent artist, if that's something that you've seen, write a letter to Congress, and it's through the copyright.gov website. I can send you the link so we could put it in the show notes.
Let's do that. Yeah.
Yeah.
I've definitely not been paid by PROs plenty of times.
Okay. Yeah. So if you have problems with them, this is your chance to be heard by Congress, because they're launching an investigation right now so that they can change it and make it better for artists across the board and not just for those big artists at the top of the game. Essentially, they said it's inefficient and the model is not great.
It's very antiquated.
Yeah. And so right now they're hoping to change it. And this is a great chance as an independent artist, as someone in the business that you hopefully will make a long-lasting career in, to be able to have your voice heard and change the way that things are done. So we'll have that in the show notes. I'll send you the link. Sure. And I invite everyone or whoever cares to write a letter to Congress and just speak your mind.
Thank you so much for sharing your expertise on all of this. I hope it's been helpful for people. One question that I ask everybody at the end of every episode is if you'd like to share a secret back to the scene here, anything that you think is a key takeaway or maybe something that you've learned from personal experience from some of the cases you've worked on, just anything that you think people really ought to know.
Yeah, again, I'll say it again. Don't sign anything that you don't understand, and don't be afraid to advocate for yourself. You are the one who's creating the art, and you're the one who's creating the product that is being sold as a business, So if someone is coming for you to you to try to make money, you're the one who's making them the money. Don't be afraid to advocate for yourself. You own the power.
Yeah. And I think even amongst, your own colleagues and peers and bandmates, like we see oftentimes a band will form and there's clearly one leader. Maybe they're the singer-songwriter or something like that in a traditional sense. And, can be a little bit scared to rock the boat and want to kind of like how Pierre was saying in his question of we've got a verbal agreement, but am I going to be too annoying to bring this up? I think it's the same thing. Don't be afraid. It's something that you need. If you're taking it serious and you're trying to make a living off of this, you're trying to be professional about it. It's okay.
Yeah.
Do what you have to do.
No one's going to be upset at you for standing up for yourself. And if they are, maybe it's not the right situation.
Right.
Yeah.
Absolutely. Okay, we've got a lot of resources we're going to put in the show notes. We'll make sure to link that. If somebody wants to get in touch directly with you or with the Spence Law Firm, how do they go about doing that?
Yeah, so you can find the Spence Law Firm at spence.law. So that's SPENCE.law, LAW. We have our contact information on there, and you can go ahead and call us, and we'll, again, do a free 30-minute phone consultation or, talk to you to try to see how we can help you. And again, we like to advocate for artists. A good lawyer is a great part of your team, and we hope to be a part of your team. So we're going to help you. If there's something that we think that you can do yourself, we'll tell you that. If it's something that, maybe is not as cost effective, I know Mick is very mindful of how cost effective we are for the client, and I am too. And we want to help you out. So you can get in contact with us through spence.law, SPENCE.LAW.
Awesome.
Yeah.
Jonathan, thank you so much for doing this. Really appreciate it. And everybody that tuned in for this episode, thank you so much for giving me some of your time. Please share this with another DIY artist that you think might need to learn some of this or hear some of this. It definitely helps us out. And if you haven't already, please subscribe, leave a rating, all that kind of stuff. I appreciate everybody. We'll see you next time.